Thank you. Thank you, Tony West, and to all of my colleagues here. The last time I was in this room was just after President Obama had announced the formation of our working group, and I stood here with my colleagues to speak about the mission of this enterprise. And very simply, we're investigating the misconduct of folks who caused the bubble in the housing market and the mortgage-backed securities market that brought about the crash of 2008, creating the most severe recession since the 1930s. And I am very pleased to report that an incredible collaborative enterprise has been underway since then, and that we are here to announce that my office filed yesterday a complaint for securities fraud against JPMorgan Chase and two of its subsidiaries, largely in their capacities as successors to Bear Stearns Co. and EMC Mortgage Corporation. This complaint, which, as we have noted and will be noted again today, is just the first case made public by the working group. But this complaint, I think, goes to the heart of the misconduct that created the bubble and crash. It alleges flagrant misrepresentations and material omissions by one of the top sponsors of residential mortgage-backed securities in the world. Specifically, we allege that the defendants repeatedly assured investors that they carefully evaluated the loans that went into their mortgage-backed securities. They also represented that they monitored the lenders or originators that they bought most of their loans from, firms like Countrywide, Greenpoint, and American Home Mortgage, to ensure that these originators were following all applicable guidelines in assessing the quality of the loans, including a borrower's ability to pay. And finally, the defendants repeatedly touted their quality control operations, which was supposed to track loans even after they were securitized, and when appropriate, required that originators take back defective mortgages. These representations were false, they were misleading, they were designed to conceal fundamental flaws and defects in defendants' due diligence systems. Defendants had no legitimate basis for any of the numerous representations about the quality of loans in their securities because their systems for ensuring loan quality were a sham. In marketing materials and other documents provided to investors, the defendants represented that in evaluating mortgage loans for pooling and depositing into their RMBS trusts, they performed, and these are their words, intensive and robust due diligence and quality control. In fact, as set forth in our complaint, rather than carefully reviewing loans to ensure they complied with underwriting guidelines, Bear Stearns and EMC executives pressured inexperienced and overwhelmed employees and third-party due diligence providers to approve as many loans as possible, as quickly as possible, without regard to loan quality. And even when these flawed processes did happen to identify some defective loans, the defendants routinely overlooked reviewers' findings and continued to package many of those loans into securities for sale to investors. I note that some executives did call attention to this, and even counsel for Bear Stearns and one of their outside auditors, they advised the company to bring its due diligence and quality control processes into compliance with SEC regulations. Those warnings were essentially ignored, and in the end, the defendants approved the purchases of defective mortgages because they viewed underwriters like American Home Mortgage, Countrywide, and Greenpoint, and not the investors who would purchase their securities as, and this is again their phrase, their number one client. They placed preserving their relationship with underwriters and the millions of dollars in fees that they pocketed from the fast-moving securitization machine ahead of their obligations to investors. When we announced the formation of this working group in response to President Obama's mandate in his State of the Union address, we announced that we would capitalize on the force of the varying jurisdictions, resources, and statutory powers of our respective agencies to maximize our reach and provide more efficient work for the people of America who are demanding justice. This case is brought by our office, the New York State Attorney General's office, pursuant to the Martin Act, but we never could have conducted the investigation that enabled us to bring this complaint without the cooperation and the collective efforts of the other members of our working group. You have already heard from Tony West, a truly great colleague in the Department of Justice. You will be hearing from John Walsh. The Department of Justice has provided us with incredible assistance. Again, we're all looking at the same materials and evidence because there are possible claims by various agencies. Instead of doing it separately in, as he said, separate silos, by doing it together, we're providing a lot more bang for the buck for the American people. DOJ has been terrific, and John Walsh, who has been coordinating the participation in the working group of U.S. attorneys around the country, will speak about that work, conducting interviews, helping our office in places where we never would have gotten, quite frankly, if we hadn't had this help. And I have to say, Steve Linick and the staff at the FHFA IG's office were extraordinary. They were invaluable partners. They also provided investigators to conduct interviews, helped us with documents, helped us develop legal theories and test out defenses and objections. And the SEC, I have to say, without hesitation, made available to all of us their teams of attorneys and experts. They hosted several conferences for working group staff and members. They shared their insights and analysis, worked with us to identify critical evidence, and helped, I know they helped me in understanding some pretty tricky, opaque financial projects. So thanks to all. And finally, you will hear at the end of this from Secretary Sean Donovan, who in many ways is, if not the architect, certainly one of the architects of this working group. The idea that we should work together, we should pool resources, we should do something that is very unusual for government agencies to get the best result as fast as we can for the American people. I credit Secretary Donovan for making this happen. This has been a great collaboration. It continues to be a great collaboration. There are more cases to come. And with that, I want to bring up the great United States Attorney from Colorado, my partner in this enterprise, John Walsh.